The attorney was already closing his briefcase when the CFO stood and said 7 words that made the entire room go still. Jonathan Cross had built Castellan Industries over 30 years with one unshakable rule: read everything twice. He sat now at the head of a boardroom table, hands folded, listening to his general counsel walk through the final details of a settlement offer. Across from him sat his CFO, Diana Garrett, a woman of 52 with silver-streaked hair, rimless glasses, and the kind of calm that came from decades of watching numbers tell stories no one else could hear. "They're offering resolution," the general counsel said. "Clean exit, no admissions. We move forward." Jonathan didn't respond immediately. He looked at the contract on the table. It was thick, bound, marked with sticky tabs and margin notes. This was the document that had started everything, a joint venture agreement signed 3 years earlier with a company called Archway Industries. The deal had been ambitious, a shared investment in automated logistics infrastructure across 6 states. Castellan provided capital and operational oversight. Archway provided technology and deployment. It should have worked. Instead, 18 months in, Archway had walked. They'd cited performance clauses, timeline delays, and a provision buried in Section 9 that allowed either party to exit under material operational failure. Castellan had lost $40 million overnight. Contracts with third parties collapsed. Partnerships unraveled. Jonathan had spent a year rebuilding what Archway's departure had shattered. The damage had been more than financial. Castellan's reputation had taken a hit. Partners who trusted them to deliver on commitments began asking questions. Industry analysts published cautious reviews. Jonathan had spent months on the phone, in boardrooms, reassuring stakeholders that Castellan was still solid, still reliable. That the failure had been Archway's, not theirs. But proving that in court had been different. The law didn't care about phone calls or reassurances. It cared about what the contract said and whether the parties had followed it. And now they were here. Civil court. Not to argue guilt or blame, but to argue language. To argue what the contract had actually promised, what it had actually required, and whether Archway had followed the rules it agreed to. The trial had lasted 4 weeks. Depositions, testimonies, expert witnesses breaking down timelines, delivery schedules, technical benchmarks. Archway's attorneys were polished, prepared, and relentless. They presented their case with surgical precision. Castellan had failed to meet operational standards. The contract allowed exit. The loss was not their responsibility. Jonathan's team had fought back with equal force. They'd shown the timeline discrepancies, the missed communications, the decisions Archway had made unilaterally without consulting Castellan. They'd argued that the exit clause had been invoked improperly, that Archway hadn't followed the notice requirements, hadn't allowed the cure period, hadn't acted in good faith. But the opposing side had one advantage: the contract itself. It was dense, technical, filled with conditional phrasing and nested sub-clauses. And in that density, there was room for interpretation. The settlement offer was simple. Archway would pay $8 million, no admission of fault. Both parties walk away. Legal costs covered, case closed. It was a fraction of what Castellan had lost. But it was something. And after 4 weeks of testimony, after watching experts argue over the meaning of words like material and operational, after seeing the judge's expression grow more tired with each passing day, Jonathan's team was ready to consider it. Jonathan's lead attorney, a man named Thomas Brenner, leaned forward. "It's not what we wanted, but it's something, and it ends this." Jonathan looked at him, then at the contract, then at Diana. She hadn't said a word. Diana Garrett had joined Castellan Industries 23 years ago as a junior accountant. She'd worked her way up through budgets, audits, financial planning, and strategic oversight. She didn't speak often in boardrooms, but when she did, people listened, not because she was loud, but because she was exact. She sat now with her own copy of the contract open in front of her. She'd been reading it for weeks. Not the highlighted sections, not the disputed clauses, but the entire document, front to back, line by line, the way Jonathan had taught her to read anything that mattered. Diana had always believed that numbers told stories, but contracts told something deeper. They told the story of what people promised each other when everything was good, when trust was high, when both sides believed the partnership would succeed. The contract wasn't just a legal document. It was a record of intention. And somewhere in those intentions, buried in the language both sides had agreed to, was the truth of what had actually been promised. Thomas turned toward her. "Diana, you've reviewed the offer. Any concerns?" She didn't answer immediately. She closed the contract and set her pen down. "I have a question," she said. Jonathan looked at her. "The exit provision," Diana continued. "Section 9, paragraph 4, the one archway invoked. I want to confirm the sequence." Thomas nodded. "We've covered this extensively. Archway claims Castellan failed to meet delivery benchmarks under subsection C, which triggered their right to exit under operational failure." "I understand their claim," Diana said, "but the contract requires written notice 30 days before exit. Did they provide that notice?" "They did. October 15th, 3 years ago. We have the email." "And the cure period?" 15 days, per the contract. But they argue the failure was material and incurable, so the cure period didn't apply. Diana nodded slowly. She opened the contract again, turned to a section near the back, and ran her finger down the page. "And the arbitration clause?" she asked. Thomas hesitated. "What about it?" "Section 12. It says that any dispute regarding contract interpretation must be submitted to binding arbitration before either party can invoke an exit provision." The room went quiet. Thomas frowned. Archway didn't invoke arbitration. They exited directly. "Exactly," Diana said. Jonathan leaned forward. "Walk me through it." Diana turned the contract so it faced the center of the table. Section 9 allows exit under material operational failure, but Section 12 requires that any dispute about whether a failure is material must first go to arbitration. Archway claimed the failure was material, but they never submitted that determination to arbitration. They decided it themselves, then exited. Thomas stared at the page. "We argued notice and cure, but we never raised arbitration. Because we assumed they could define material failure on their own," Diana said. "But the contract doesn't say that. It says disputes about contract terms go to arbitration, and whether something qualifies as material is a contract term." Jonathan's expression didn't change, but something shifted behind his eyes. He looked at Thomas. "Can we raise this now?" Thomas was already flipping through his notes. "We're in settlement, but if we withdraw and file a motion—" He paused. "This changes the argument. If arbitration was required and they skipped it, their exit might be void." "Not might," Diana said quietly. "Is." The general counsel, who'd been silent until now, spoke up. "If we pursue this, we walk away from $8 million, and we risk losing everything if the judge doesn't see it our way." "But if she does," Thomas said, "we reinstate the partnership, we force arbitration, and we argue from a position of strength." Jonathan was silent. He looked at the contract again, then at Diana. "You're certain about this?" he asked. "I'm certain about what the contract says," Diana replied. "Whether the court agrees is another matter, but the language is clear." Jonathan nodded slowly. "Then we proceed." The settlement offer died that afternoon. Castellan's legal team withdrew from negotiations and filed an emergency motion with the court, requesting reconsideration based on a contractual requirement that had been overlooked. Archway's attorneys responded swiftly, calling the motion a delay tactic. But the judge agreed to hear arguments. The hearing was scheduled for the following week. In the days between, Jonathan sat in his office and reread the contract himself. He found the section Diana had flagged. It was clear, straightforward, and it had been there the entire time. He called her in one evening. "Why didn't we see this earlier?" he asked. Diana sat across from him, her hands folded in her lap. "Because we were focused on what they did wrong, not on what they didn't do." Jonathan nodded slowly. "You've been reading this for weeks. I wanted to understand it, not just the parts we were fighting over, the whole thing. And you found this." "I found a sequence that didn't match," Diana said. "They invoked an exit provision, but they didn't follow the steps required before invoking it. That's not interpretation, that's procedure." Jonathan leaned back. "Thomas is good, our whole team is good, but they missed it." "They were reading for strategy," Diana said. "I was reading for structure." He looked at her for a long moment. "You could have brought this up weeks ago." "I wasn't sure it mattered," she said, "not until I saw the settlement offer. That's when I realized they were trying to close this quickly, and that made me ask why." Jonathan smiled faintly. "Because they know." Diana didn't smile, but her eyes said yes. "There's something else," she added. "When I went back through the correspondence from 3 years ago, I noticed that Archway's legal team changed about 6 months before they exited. New attorneys, new leadership, different approach. You think the new team didn't catch the arbitration requirement either?" "I think they inherited a strategy," Diana said, "and they executed it without questioning the foundation." Jonathan considered this. "So we're not just arguing against Archway, we're arguing against an assumption both sides made." "Yes," Diana said, "and assumptions are dangerous when they're written into action." The courtroom had wood paneling and high ceilings. The judge was a woman in her 60s named Alice Brennan, sharp, patient, and visibly uninterested in theatrics. Before the hearing began, Diana sat in the gallery and thought back to the day the contract had been signed. She'd been there 3 years ago, watching Jonathan and the CEO of Archway Industries shake hands over a partnership both sides believed would redefine logistics infrastructure. The contract had taken 9 months to draft. Teams of attorneys on both sides, every clause negotiated, revised, finalized. Diana had read it then, too. She'd flagged a few sections for clarification, minor points about payment schedules and performance reviews. But she'd also noticed Section 12, the arbitration clause. It had seemed standard at the time. Boilerplate language. The kind of provision that existed in every corporate contract as a safety net, rarely invoked, rarely remembered. But she'd made a note. A small notation in her personal file. "Arb required before exit." She hadn't thought about it again until last month, when she'd started reading the contract from the beginning. And when she'd reached Section 9, the exit provision Archway had used, she'd remembered that note, and she'd started tracing the procedural steps. Archway had sent notice. They'd documented the alleged failure. They'd exited. But they'd never submitted the dispute to arbitration first. They'd skipped the safety net entirely, and no one had caught it. Not Castellan's attorneys, not the expert witnesses, not the opposing counsel who'd been so confident in their interpretation that they'd never questioned their own procedure. Diana had caught it because she hadn't been looking for a strategy. She'd been looking for the truth of what the contract actually said. She remembered something else, too. During the original negotiations, Archway had pushed hard for that arbitration clause. They'd wanted a neutral third party to resolve disputes before either side took unilateral action. It had been their safeguard against impulsive decisions, against exactly the kind of sudden exit they'd eventually executed. The irony wasn't lost on her. Archway had insisted on a protection they'd later violated. Now, sitting in the courtroom, she watched as Archway's lead attorney stood and argued that the motion was procedural gamesmanship, that arbitration had never been necessary because the failure was clear, documented, and undisputed, that Castellan was grasping at technicalities to avoid an outcome they didn't like. Thomas stood and responded with precision. He didn't raise his voice. He simply read from the contract. Section 12, Paragraph 2. Any dispute regarding the interpretation, application, or enforcement of this agreement shall be submitted to binding arbitration prior to any unilateral action by either party. Archway determined that the failure was material. That determination is an interpretation of the contract. It required arbitration. It didn't receive it. Therefore, the exit was procedurally invalid. Judge Brennan looked at Archway's attorney. "Counselor," the man stood again. "Your Honor, the clause refers to disputes. There was no dispute. Castellan missed benchmarks. That's factual, not interpretive." But whether those missed benchmarks constituted material operational failure under Section 9 is interpretive, Thomas said, and that interpretation triggered their exit, which means it required arbitration first. The judge was quiet for a moment. Then she looked at Diana, who was seated behind Thomas in the gallery. "Ms. Garrett," the judge said, "you're the CFO of Castellan Industries." Diana stood. "Yes, Your Honor." "You raised this issue?" "I did." "And you've read the entire contract?" "Yes." "Tell me," Judge Brennan said, "when did you first notice this discrepancy?" Diana paused. "About 3 weeks ago, Your Honor. I was reviewing the contract in full, not just the disputed sections. When I reached Section 12, I remembered making a note about it during the original negotiations. I checked my files and found that note. Then I traced the procedural steps Archway had taken." "And what did you find?" "That they'd followed some requirements but not others. They'd provided notice. They'd documented the alleged failure, but they hadn't submitted the question of materiality to arbitration before exiting." Judge Brennan nodded slowly. "Sit down, please." Diana sat. The judge turned back to the attorneys. "I'm going to take this under advisement. You'll have my decision in 72 hours. As the courtroom emptied, Diana remained in her seat. She thought about all the hours she'd spent reading that contract. Not because anyone had asked her to, not because it was her job, but because something had felt incomplete. Because $40 million and a damaged reputation deserved more than a settlement that acknowledged nothing. She'd spent her career believing that numbers didn't lie. But she'd learned something else over these past weeks. Numbers told you what happened. Contracts told you what should have happened. And the gap between those two things was where justice lived. 3 days later, the ruling came through. Judge Brennan found that Archway Industries had failed to comply with the arbitration requirement prior to invoking the exit provision. As a result, their departure from the joint venture was procedurally improper. The exit was voided. The partnership was reinstated retroactively, and Archway was ordered to either resume performance or enter binding arbitration to determine whether a material failure had actually occurred. Archway chose arbitration. The arbitration panel reviewed the case over the next 6 weeks. They found that while Castellan had experienced delays, those delays did not meet the threshold for material operational failure as defined in the contract. The benchmarks in question had been ambitious but achievable. The timeline disruptions had been minor and, importantly, had been caused in part by decisions Archway itself had made without proper consultation. The panel noted something else. Archway's internal communications, submitted as evidence, revealed that their leadership had been under pressure from investors to exit partnerships that weren't immediately profitable. The decision to leave hadn't been driven by Castellan's performance. It had been driven by a strategic pivot Archway's board had decided on independently. The contract breach hadn't been about operational failure at all. It had been about convenience. Archway's exit had been premature and, the panel concluded, made in bad faith. The panel awarded Castellan $22 million in damages, plus legal costs. Additionally, they required Archway to issue a formal acknowledgement that Castellan had not materially breached the contract, a statement that would be made public and filed with industry regulators. For Jonathan, that last provision mattered almost as much as the financial award. It restored what Archway's departure had damaged, Castellan's reputation. The case was over. Jonathan Cross stood in his office one evening. Behind him, Diana sat in one of the chairs. "You saved us," Jonathan said. Diana shook her head. "I read a contract." "You read it the way it was supposed to be read." She didn't respond immediately. "I've been doing this for 30 years, Jonathan said. "I've built this company on reading the fine print, on understanding the details, and I still missed it." "You were managing a war," Diana said. "I was managing the map." He turned to face her. "I'm not sure I've ever properly thanked you for that." Diana met his eyes. "You gave me a place where reading the map mattered. That's enough." Jonathan nodded. He sat down across from her. "They'll appeal," he said. "Probably," Diana agreed. "But the foundation is solid now, and they know it. Because you found the crack in theirs." Diana was quiet for a moment. Then she said, "The contract was always fair. It just needed someone to enforce it fairly." Jonathan smiled. "That's the part people forget. The law doesn't care what's loud. It cares what's true." Diana folded her hands in her lap. "I think that's why I like numbers and contracts. They don't lie. They just wait for someone to read them." "Do you remember the day we signed that contract?" Jonathan asked. "I do. You flagged some sections for review." "Minor things," Diana said. "Payment schedules, reporting requirements. But you also noted the arbitration clause." Diana looked at him. "You remember that?" "I remember you put a sticky note on page 47 that said, 'safety net.' I asked you what you meant. You said it was there in case either side forgot how to talk to each other." Diana smiled faintly. "I'd forgotten I said that." "I hadn't," Jonathan said. "Because you were right. That's exactly what it was. And when they stopped talking to us, when they just decided to walk away, they forgot the safety net existed." "Or they hoped we'd forget," Diana said. Jonathan leaned forward. "Thank you. Not just for finding this. For remembering what mattered when everyone else had moved on." Diana nodded. She stood to leave, then paused at the door. "Jonathan," she said, "the next contract we sign, I'd like to be in the room when we negotiate it." He looked at her, surprised. "You've never asked to be at the table before." "I know," Diana said, "but I've learned something. It's easier to enforce a fair contract than to fix an unfair one, and I think I can help make sure we start with fairness." Jonathan smiled. "You're already at the table, Diana. You've been there for years. I just didn't make it official." "Then make it official," she said. "Consider it done." They sat quietly, knowing that sometimes the smallest details carried the greatest weight. Months later, Archway Industries settled the appeal before it reached court. They paid in full and issued a formal acknowledgement of procedural error. The public statement was released, clearing Castellan's name in the industry. Analysts who'd questioned Castellan's reliability issued corrections. Partners who'd hesitated returned. The case was closed. Castellan Industries moved forward. New partnerships, new projects, and a reputation that had been tested and had held. Diana Garrett remained CFO. But now, whenever Castellan negotiated a major contract, she sat at the table from the beginning, not just reviewing numbers, but shaping terms, making sure that what was promised was clear, that what was required was fair, that the safety nets were visible, understood, and respected. She continued reading contracts, financial statements, and the stories numbers told when no one else was listening. She didn't seek recognition. She didn't need it. But in boardrooms across the city, her name was quietly spoken with respect. The woman who'd read the fine print. The woman who'd found the detail that mattered. The woman who'd proven that careful attention was more powerful than loud arguments. Jonathan began to notice something else. Other companies started reaching out, not for partnerships or deals, but for advice. They wanted to know how Castellan had navigated the dispute, how they'd found the leverage, how they'd turned a case they were losing into one they'd won. And every time, Jonathan directed them to one person. Diana. She never gave interviews, never wrote articles, but she did consult quietly for companies that found themselves in similar situations. Companies that had missed something crucial. Companies that needed someone who could read what everyone else had overlooked. She did it not for recognition, but because she believed that contracts, when written and enforced fairly, protected everyone. That the law existed not to create winners and losers, but to hold everyone accountable to what they'd actually promised. And in Jonathan Cross's office, on a shelf beside the contracts and the deals and the years of building something that lasted, there was a framed copy of Section 12, Paragraph 2. Not as a trophy, as a reminder that fairness isn't loud, it's careful, and it's worth defending.